Your Excellencies, every action Revisia has taken throughout this conflict has resulted in a serious violation of Alicanto's sovereign rights as a state, the foundation of international law. They justify their armed presence in Alicanto under the doctrine of collective self-defense. However, as Your Excellency pointed out, no armed attack against a third party has occurred since the termination of UNMORPH. Revisia further justifies its presence by mentioning scholarly commentary supporting the principle of humanitarian intervention, ignoring the fact that the present circumstances constitute preemptive humanitarian intervention, which cannot be justified under these same sources. Moreover, Revisia has conceded that this intervention may not have been couched entirely in humanitarian intentions. Finally, no claim can be made that Revisia has been inactive in quelling the disturbances. In fact, Revisia's hands have been, or Alicanto's hands have been tied due to the presence of Revisian forces on Alicanto's sovereign territory. Revisia justifies its pollution of the Alicantan airwaves under the motive of progressive development of Alicantan communities, as justified under human rights law. However, this is subject to a strictly Revisian definition of what constitutes progressive development. Furthermore, the hypocrisy of justifying action as progressive development while simultaneously engaging in acts of sexual exploitation with starving and vulnerable Alicantan children bears mention. As far as the sexual exploitation is concerned and the UN's position whether or not to grant immunity is clear, no explicit waiver of immunity is required as the UN's position is clear. Zero tolerance for acts of sexual exploitation by peacekeeping forces. Nevertheless, this is irrelevant, as Alicanto is not obligated to respect these privileged immunities due to Revisia's material breach of the Status of Forces Agreement. Moving on to the situation surrounding fugitive Picardo Donati, Revisia bases its entire argument on the fact that no extradition treaty exists, ignoring the residual effects of such a determination. The nature of Mr. Donati's offense prevents asylum from being granted and obligates extradition or prosecution. However, the lack of a sovereign claim to the Alicantan territory prevents this obligation from being upheld. And ultimately, by not mandating Revisia to turn this fugitive over to Alicanto, the court will be implicitly condoning yet another violation of Alicanto's sovereignty, that being the rendition of Mr. Donati from Alicantan's sovereign territory back to Revisia to stand trial. Concerning respondents' reliance on the Libya case to base its refusal to extradite, Libya was economically sanctioned by the United Nations, which certainly implies that the state was not in alignment with international law and how it had handled the situation. Finally, despite repeated violations of Alicanto's sovereignty, Revisia now wishes to rely on its own sovereign right to classify evidence. If evidence of genocide does exist, Alicanto wishes to be made aware of it so that it can act to prevent such occurrence as its own sovereign right to handle internal conflicts. Furthermore, by consenting to this court's jurisdiction, Revisia has consented to the issue of whether the UN may lawfully hand over this evidence. Alicanto is not asking the court to compel the Secretary General to turn this evidence, simply declare that it may be lawful for him to do so. And if this evidence is not produced, Alicanto asks that Revisia may not be able to use it as an evidentiary benefit. Thank you, Your Excellencies.
Thank you.
May it please the court.
You may proceed.
Collective self-defense is valid in this instance. The armed attack that occurred against the New Benue Plain did incite and further exacerbate the ethnic conflict and violence on the ground. That condition was never remedied. Whether the position and the UNMORPH presence was there was a mere control. If the UNMORPH termination were to truly occur and troops were to truly leave upon 31 July 2008, immediately the threat to the peace would resume. And in fact, the Security Council noted 3 days prior to that expiration, the threat to the peace still occurred and still existed in the region. States should not be required to pull out troops in such a situation and expose themselves to further attack and further gun smuggling amongst the borders in such a situation where they have already positioned themselves and previously been authorized. Also, Alicanton police did stand by while conflict broke out in their own territory and were apathetic to the suppression of this violence. In fact, citizens were killed in a demonstration while Alicanton police stood by, and the situation was not pacified until OPS troops arrived on the scene, OPS troops being Rhodesian troops. It should be noted that the troop contributing country is given discretion through the SOFA to prosecute unofficial acts. Sexual exploitation is undoubtedly an unofficial act of any peacekeeper. It cannot be used as a proper tool in peacekeeping. Thus, the individual bad acts of the soldiers must be prosecuted and punished under the TCC's authority. None of this authority has been given to Alicanto through the SOFA or through other customary international law when sovereign military presence is in another sovereign territory. Finally, Alicanto relies upon state secrecy classification and protection as well as Rhodesia does. As previously stated, this means a principle, international principle amongst the two nations exists that must be recognized, and that the classification and non-production of that evidence is proper.
We only had 3 minutes for rebuttal.
We reserve 3.
Oh, I'm sorry. I got it. That's why I just was going to call time. Yeah.